And throughout the bill, I can't recall, and I believe raising it, the psychological impact. If somewhere along the line that can be taken into consideration, because we do have situations where workers are required to take breaks rather than being before even a monitor for a prolonged period of time. And especially in the call centers, they are required to take breaks rather than being on these calls never ending. And that can, it has been cited where that can lead to psychological impact on the worker. So, Ministry, I would like to hear your views on that.
Ministry.
All right. Just want to remind everyone that within the workplace, it is the employer, the PCBU, who has a primary duty of care to identify significant hazards in the workplace, to set out safe system of work, including appropriate control measures, equipment, competencies, and training, and effectively implement them so that the safety and health of the worker is preserved. Now, once all of these things are in place, we have a safety and health representatives, we have the Joint Safety and Health Committee in operation, then we should have a workplace where all the risks that could result in, as Member Gale mentioned, in 35, 36, 37, these are events after, that these do not happen to the detriment of the safety and health of the worker. So this mechanism is something that, in the ideal situation, you might say, would not warrant being triggered, because the appropriate risk assessment was done by the PCBU and a safe system of work and the other safeguards are put in place. So what we were contemplating for this is that in situations where it is missed, and then in these situations where it is imminent and immediate exposure, this is where you are trying now to trigger this mechanism to protect the worker. Responding to Member Gale's trying to create that link or that nexus between it, is that we introduce the word risk, because risk inherently speaks about probability of occurrence, which is future. So it is not intended to be looking at it as the outcome of the exposure. That is why we use the word risk, to speak about future. So if you are in the workplace, whether it's an office, whether it is an industrial establishment, the PCBU should have done a risk assessment to know what are the hazards in the workplace. If it is to do with air quality, what should be, for example, the level of carbon dioxide, the level of oxygen must be in the workplace. He must know what are the safeguards that need to be put in place to preserve the safety and health of the workers. So for this clause, what we are saying is that we need to have the measure, and to make it easy and simplified, that measure would have been trying to create that nexus between the exposure, the probability of exposure, the risk, and the outcomes that can occur. So if he's working at height, there's a risk of fall. If you look at 35, what is here? Any of these, 36, any of these outcomes could have occurred if that worker falls. So that is what we are trying to ensure, if it's captured there, and if we need to redraft to do so, then I'm not aware. I think the ministry is not averse to that.
Yes, Mrs.
I hear the ministry saying that they are prepared to redraft.
Yes.
And it's comfortable with me. Just one thing though, Mr. Mahan. the employers, you say, ought to pay attention to these things. But there's another thing that they pay very keen attention to oftentimes. It's called profit. And sometimes they conflict. And sometimes they conflict. And so you can't just leave it up to them, which is where I think the bill is going to say, bring the worker in. There's two cases that keep coming in my mind where this bill would have benefited the employers. The Chanos case. You would know that case, Chairman. And the Jamaica beverage case, where the company just got wiped out because of a safety issue. Chanos is strong enough to survive, barely. So, we need to sell this to the employers. That is to protect them as well. And I say that because if I was being provocative as an employer, I would say what the ministry is doing is opening the door for every worker to say, I'm not working today because of a perceived safety violation. It may be the air quality. It may be some door not being kept closed. And on the contrary, it may be that some door is locked and I can't get out quickly. So maybe it's part of the marketing I raised those two. But I'm happy that you're going to rework this so that the employers may find some comfort in the good thing of allowing the worker to say something is wrong.
All right, very well. The ministry has indicated that it will revert to the committee in respect of clause 84. So we can proceed to 85. And AGC, I see here you have raised an issue to which the ministry has commented, but I ask that you take us to the concern.
Yes. Good morning, Chair and members. Apologies for being late this morning. In relation to clause 85, the first comment we had was that whereas we didn't understand why the clause would be asking for the issuing of a direction to the worker to refuse to work. We also thought that if we're dealing with refusal to work, it should be accommodated under clause 84 and not clause 85. But the whole concept of issuing a direction to the worker to refuse to work was something we also really didn't understand. We could understand issuing a direction to cease to work, which is a different concept. The ministry, in any case, we thought it should have been addressed under clause 84 and not clause 85, and the ministry accepted the point.
At the same time, take us through your second point.
Thank you, Chairman. We'd ask for the clarification of the meaning attempting to resolve the matter as an issue, which is used in clause 85 2b. And we'd also point out that the references to clauses 84 to 89 in 85 2b and 85 3 were incorrect. The ministry responded to that latter point. I don't think they responded to the issue of explaining what you mean by attempting to resolve the matter as an issue.
Ministry.
Minister, in light of what we said at the previous meeting in relation to matter and issue and setting out the procedure to be followed, that would have to be a part of the rework because it was meant to be the procedure under clause 81. But because we have been decided to merge 49 consultation and just set out the procedure, what is intended that you should have consulted, you should have done certain steps before you exercise the right. So we would have to tie it up and link it to the new procedure we promised to set out, where we had merged the consultation and then how you escalate to an issue and then escalate to the tribunal.
Very well. Members?
I agree with taking out that instruction for the worker to refuse. Because when I look back at the functions of the health and safety officer, I don't see where the health and safety officer can make that instruction. But if the health and safety officer upon investigation or inspection cites that there may be imminent danger, can instruct for the worker to cease, but not to say to the worker that you must refuse. So we have to take out from 85.2 the word refuse.
85.2 as 85.1 and 2 or 85?
I'm seeing it.
It's
Yeah,
in 1,
85.1 and 2. The words refuse.
Mhm. Which is a suggestion that the ministry, yes.
I want to seek a clarification too in 85.6b. So this is speaking now to a safety and health representative cannot give a direction under this section unless the representative has completed initial training and certification. But B is suggesting that the representative should have completed that training and certification previously when acting as a safety and health representative for another work. And we're talking about workplace. But suppose I was never at the previous workplace a health and safety representative, but I had gone through attaining certification. Could I not be in a position to give the directive? Because I would have had the training and certification, but not necessarily nominated as a safety rep at Senator Brown's Aki Farm.
In respect of 6, subclause 6, Ministry?
All right. The training and certification is important, as you would have mentioned, because it is how you are able to recognize and control the hazards. But we want to ensure that under this regime, the representatives of the worker, they are the ones who have that as their power, once they have the training and certification in that workplace, to be able to issue that direction to cease.
No, man, I'm suggesting to you that at my previous workplace, I was not a health and safety representative, but I have the qualification and certification that you demand.
But it is clear, Member Gill, it says when acting. So it went beyond just having completed the training and certification. It says when acting as a safety and health representative for another workplace. Since we, yes?
Wouldn't it be tidier to make this a condition of appointment of the safety and health representative, and that's one of the comments I'm making. Move it to that provision, and I would like to ask the ministry, I don't think this provision needs to be so complex. And I would like to just ask them to look at the provisions that I gave them in relation to the procedure under the Ontario legislation, which has the same health and safety committees where they don't speak about risk, but it's a much simpler procedure for the whole, to deal with this entire issue, and see if we can simplify how we have drafted it under this legislation. I don't think it needs to be so complex.
Chairman.
Yes, member.
Problem is, road to hell is paved with good intentions. It's hell. Let's take, for example, if I am an untrained worker in health and safety matters can say, I am not working at that machine. That's fine, under 84. But somebody with a year or 2 year experience at health and safety, but does not have the specific qualifications at 85.6, can't tell me who is a new person now in the department that machine is unsafe and you should work on it. Strike me that we have a conflict there. Maybe the worker who comes in today, brand new, can say this machine is unsafe. But the representative can't unless the representative goes through, I don't know if that's one of those fires things. Unless, oh, I see. Unless the worker goes through all of these training. So maybe it's too onerous a requirement to have that clause there, have that requirement for the health and safety person to be able to say, you can't work. And that worries me, because there is not a continuity between me, the untrained safety and health worker, and the other person who may have gone through one course and maybe in a better position than me. I think we're requiring too much of this health and safety rep. And just to the point that Mrs. Celia Brown made, we run the risk of not having any health and safety rep, because if these are the requirements for me to be able to carry out the function, then it makes no sense me volunteering to be elected to the position. Again, Chairman, I want to say this. I think there's too many drafting issues with this bill, and we are reverting, and we're not being. And again, I know our intention, but the time is up on us fast. I'm hearing conflict that certainly by the middle of February, there's going to be prorogation of the thing, and it can be carried over. It can be carried over, no question, assuming no other event takes place. it get carried over. But if a new event takes place, it has to come back brand new. I don't know what. So for those reasons, I really am wondering if we shouldn't make some assessment that based on all the discussions we have had thus far, to look to see how we can sharpen and better the thing. Because I'm concerned about the pace we're going, too slow, but I understand why we're about to be going this slow. Because this, Chairman, this is so fundamental a change in the workplace relationship that every time I see Cavan Gale and myself accompanied by Member Brown Burke and Senator Skeffrey, I fear the accusation being made that it is those who favor what is right and just that draft and contribute to the drafting of this bill, and that those who may want to keep some of the status quo have stayed away. They have to take the blame. We invited them. But I still feel that deep down in me, the workplace requires all of us to cooperate. It requires all of us to cooperate. And I'm not feeling the cooperation and resistance that comes from cooperation sometimes from the employers class. And I know this clause, for example, the one that they may not oppose to in principle, but they would have some nuances which they want to share with us. Because I can see safety in our workplace being a cause for more disruptions than we have had for wages, suspension, etc. Because it depends on how I feel on a Monday morning when I come into the workplace. I might find that the workplace that was so cool on Friday, payday, is so terrible without any change of condition on Monday morning. And I could see workers finding reasons to say, I now work at a machine today. So it is, I don't know how we can get them into this. But I like the clause. I love it. But as a union man, but I know that the unions are not alone in the workplace. Yeah. And that's my concern.
Yes.
I'm agreeing with what Senator Brown is saying, and to add also that I think it needs to go further. You can't just give the person the right to cease work. What happens after? Because I'm looking at other legislation where there's a procedure for an investigation to be conducted, a report to be made, and what happened to the worker during that time. So there's a procedure that should follow after something like this takes place, and I'm not seeing that sort of a procedure highlighted in
88
this bill.
speaks to, have you looked at 88? Is that sufficient? Yes, Mrs. Benny-Campbell.
Minister, we have a whole set of proposals here building in that procedure. It's just that we haven't reached there yet.
Okay.
We looked at all those jurisdictions and we realized there were some gaps, so we have the mapping going there.
Yes, and Member Brown, I will respond to you because I know you have raised the question of the pace at which we are going. I mean, I'll take you back to when we started. I mean, we were having real issues in terms of how the bill came to us. And I know from the ministry and continuous work is going in to see how we can improve the final bill. But as you are aware, the discussions must take place here. And when we have the discussion, we may very well have to go back having regards to the discussions that come out. So, yes.
Chair, I think whilst I can understand Member Brown's concern with the pace, I am satisfied how we are running, because what this committee and the legal teams are doing is really going through in detail what the bill should represent at the end of the day. And it's bringing the minds together, it's bringing the experiences together, and it's bringing the knowledge that is in this room with the inclusion of those persons who would have represented here as stakeholders. So I think we are doing the right thing. But he made a point that we ought not to just gloss over in terms of getting the details right, because I know some workplaces that are organized that will pick areas of this bill to create disruptions. I'm not necessarily saying that it's limited to any one trade union, and much less a workforce that is not organized, because those that are organized, the trade union leaders can get them back to work. But can you imagine somewhere where you have a group of workers that don't have that privilege, a workplace that don't have that privilege of organized labor, to create a disruption because I feel today that I don't want to work with this man or this employer, and I'm going to disrupt it based on some of the areas that are written in this piece of legislation.
All right. Well said, Member Gill. Yes, Member Brownberg.
I just wanted to add, I agree with the concern raised, certainly by Member Brown. And I do know that we had members from the private sector who had given their recommendations and their comments. But I was just thinking that in the same way as we go through the bill, we are finding that there are some areas where some significant changes and rewrite need to be made. Then I think that those same stakeholders that we had consulted with, we had spoken with, could quite reasonably say that they almost have not gotten an opportunity to respond now to some of the major changes that we are making. And I understand the process in terms of how it goes, and that this is a committee where that discussion is made. And I did say before, and I was reminded that we do not want to open the door all over again. But as Member Brown said, I'm not sure if there is some other way just to ensure that we have the kind of cooperation, the kind of buy-in, given some of the concerns that we know are inevitable, and some might even be considered unreasonable. But just to make sure that we can strike that balance of this bill actually working as it is intended, because we're not trying to create two groups working against each other, but rather we are trying through this bill to find a mechanism where they work together for a safer and healthier workplace. So I mean, that still remains my concern, and I want to add my voice to what Senator Brown has said.
Having heard you, Member Brownberg, I want to remind us that the committee took a position that we were going to issue a letter inviting members of the Employers Federation, and we would have copied the Manufacturers Association and the private sector organization, and that was done in excess of a week now. They responded to say that they will join us. They are in the process of finalizing who their member is, or their representative who will participate in these proceedings. So we expect their participation anytime now.
Chairman, thank you for the announcement, because we were unaware of that, and we're very happy that they are coming. Because you see, at the end of the day, we don't want them to say they didn't know. And Scotland. I was just saying to Senator Gill, there have been bills in the past fundamentally changing things, but for which both sides of the aisles take up different positions. I can recall the NIS bill. I can recall the NHT bill. Different positions. Though in the end they come back and work together on them. And this is the most revolutionary thing since the 70s legislation. The LRID, right to join trade union, right not to be dismissed without fairness. This bill changes a lot. And we need a buy-in. Both sides of the aisles are at one on this bill. The opposition, whoever may be there now and in the future, and the government, whoever may be there now and in the future, share support for this bill. So there's no disagreement between the parties. But the stakeholders in the society are not just the PNP and the JLP. They are the employers, and there are thousands of them, and their employees, and there are 1 million plus of those, and we need to get that buy-in. We need to get that buy-in, and so I'm glad, Chairman, that the private sector, the employers have responded positively. I'm minded to ask, in light of that, and given how fundamental this bill is, whether any contemplation was given to ensuring that employers take out insurance. Because if I own a motor car, the law requires that I carry an insurance, maybe a third-party insurance minimum. Many companies have suffered and this because of an absence of insurance. The two cases I mentioned, for example, are but just two examples. There are many more. Are we going to get to a point where we require companies to take out insurance coverage to deal with health and safety? I'm not proposing it now. It's part of the thing in my mind. It's going to cost more. It's going to put a cost on business. But is it something that we should contemplate? Because when you give workers rights like these, it becomes justiciable. And who pays? Those are some of the issues I think we may find coming up in the conversation.
Yes, thank you, Member Brown. I'm sure the matter of insurance, as you rightly say, will not be something that is considered now, but when the bill comes up for review, certainly that may be something that is looked at. Proceeding Ministry, 85-6, did we respond to the concern raised? And the suggestion made by CPC?
Yes, we did. We gave an explanation in terms of what was raised by Member Gale, concerns as relating to training and all of that. And we said that we would look at it and see how we can redraft it to fit within what was discussed in relation to the whole thing about future and ensuring that we're looking at it from the risk. That's 85-6? Oh, 85-6. In terms of the safety and health representatives giving the direction.
We just wanted to clarify for the records that it's not a requirement for you to have the training and certification to be elected, but we looked at the provisions that require the PCBU to train you once you're elected, because if you put in the requirement from day one, see that this law is new, then we would have no safety and health representatives, nobody at all, which is why we were looking at all that detail about the training in this, I think it's 72. So the mandatory training, and you did send us back to do some work there, so it would have been 72(1)(b), that once it is you are a safety and health representative, once you're elected, at least you should have been able to do that minimum training. And what we were saying, why the training was important, that we were trying to emphasize last week, is that it's tied into your authority to actually say you have what it takes to tell somebody that they can cease work. So I'm just saying that it was not a prerequisite for you to be trained before elected, and we had said it from the beginning. You were asking us why then, and it's because, as we were saying, you would not have that training necessarily. You may have if you were a safety and health representative already, but this bill is new too. So the pool of people who you could be able to elect at this time would be extremely limited. So that is why it envisions you getting the training at least after you have been elected at a minimum. In relation to, there's something I had not gotten to.
There's a question on that though.
Yes.
I hear you, but it seems to be highly bureaucratic because if the worker can refuse without being trained, the safety representative is also a worker representing the workers, then why restricting this individual in carrying out some of his or her natural duties? So I'm not clear as to, though the bill is new,
You can only stop yourself.
but remember now,
Others.
so if I'm the safety and health representative, I am new, I don't have the training, and I see dangerous risk in an environment where my workers are, and as their representative, what do? Whisper to them and say, okay, but I don't have no formal rule to say as a representative, this is dangerous. So I see acid leaking.
And work, I mean work.
So I come into the workplace, be practical now. Workers are there, they don't even observe it. But I see acid leaking all over the floor. But because I don't have any training as yet, or certification, then I must just turn a blind eye. And what do I do? No? So I can't go to management and say, okay, refuse for the next half an hour, or cease. Let us deal with this issue right now and get back the environment to where we want it. Why restrict? Whereas if another worker passes by, who is not the representative, that worker could so do.
For himself only.
Yeah. And then took each other and say, follow me. Make it highly informal. So why? I understand. You see, this is a voluntary position. The point has been made time and time. I'm going to reinforce it. It's not a paid position. It's not an interviewed position. And to put so many burden, quote unquote, on this person, that is really there. It's like the union rep, you know. But this is a rep in a specific role. And I understand order and understanding the safety. But it's really more a cultural change. So I don't understand why, as a rep, I can't alert my troops, so to speak, that danger is ahead. Why restrict me?
Not troops, your co-workers.
Your co-workers, yeah. I'm trying to be as.
I know, your co-workers.
Yeah, I couldn't agree with that. And to say it's a new bill and the training don't take place yet, can't be practical.
Member Brown-Burke.
Yeah, well, just to be clear that it doesn't say that it's because it's a new bill and the training hasn't taken place yet, because you could have a situation where the employers who have the responsibility of making sure that the training is offered, that it's not offered in time, or that courses that are that would have been available are full, or other circumstances which would have been not courses are going to be full, which would not be something that the representative has refused to do or has not tried to do, but that they just have not been able because of these other circumstances. And I am wondering if the intent is that these individuals then would not be able to carry out their responsibility, although there is nothing else that they could have done as it relates. In this case, I'm talking about the training and certification. So I'm just wondering how that works.
Yes, Mrs. Bennett Campbell.
Well, in relation, the SHR can carry, remember the sections that have the functions of the SHR, they can carry out all their functions, but in relation to the issuing of the direction to cease work, that is where we're linking it to the training. But I was also trying to read in that if you notice in the bill, there's a weakness, because while there's a mechanism for the SHR, who has directed the worker to cease work, there's no mechanism for the worker in terms of what must happen next. So we were trying to read in that the worker must also follow the same procedure set out in 85, which will be amended as to when they are going to exercise the right. And upon ceasing or refusing to carry out work, the worker is required to immediately inform the person conducting the business or undertaking and the safety health representative for the workplace, if any, of the cessation or refusal and of the circumstances that gave rise to same. Let me go slower. You didn't have to ask, I realize.
It's on the matrix.
It is on
26.
the matrix, under clause 84. I hadn't gotten to reading the amendment before we had moved on, or the proposal. But no, they have a different version. 37? I understand it's page 37.
Yes, I have 26. I have on mine, members.
26?
Yes.
Huh?
It should,
Oh.
apparently. Yes, the ministry's comments. That begins with clause 84.
Clause 84, the last thing under 84 before you get to clause 85 and AGC. It says clause 84 is to be amended by the addition of provisions similar to those contained in clause 85, 2 and 3. The effect of this amendment is that the worker should normally consult with the person conducting the business or undertaking and follow any agreed procedure before the worker takes the step of ceasing or refusing to work. Upon ceasing or refusing to carry out work under this section, the worker is required to immediately inform the person conducting the business or undertaking and the safety and health representative, if any, of the cessation and refusal and of the circumstances that gave rise to same. Because if you will notice, while there's all this procedure on the SHR, there's nothing in relation to the worker who has ceased and what happens next. Not even to tell the SHR in the workplace that I have ceased work, so that it can trigger the steps in terms of the investigation that needs to occur.
Yes.
Here my concern with this, because when you look at any of the areas of this piece of legislation that can give rise to a dispute, it is this one. And it also contemplates that it's not just a worker, but it may very well be a group of workers. And whilst it outlines a procedure that can be contemplated, which includes but not limited to alternative work, what happens in the case where there's no agreement or a dispute arises? Would the ministry be prepared to examine going a little further? Because we might not agree, you know. The employer might say, but you're not exposed to any serious risk. There's no problem.
Clause 89, I don't know if it addresses the concern you're phrasing. Mrs. Bennicamp?
I would need to jump ahead to clause 89 in the matrix. I'm not sure what page you have. I have 42 under the comments of OCPC. It's only 189, so you should be able to find it. So we were proposing, just jumping forward to show you where we're going. Clause 89 is to be deleted. The following is to be inserted in provisions addressing the right to refuse unsafe work in an appropriate place. A worker is prohibited from exercising the right to cease or refuse to carry out work, and a safety and health representative is prohibited from directing a worker to cease work where such work, because of its nature, inherently or usually carries an understood risk to safety and health, and such risk is a normal condition of the worker's employment, and the person conducting the business or undertaking has taken the necessary steps to minimize the risk to safety and health so far as is reasonably practicable. Are you with me?
Up with you by reading as slowly as how fast you are.
Okay, I will go again. A worker is prohibited from exercising the right to cease or refuse to carry out work, and a safety and health representative is prohibited from directing a worker to cease work where such work, because of its nature, inherently or usually carries an understood risk to safety and health, and such risk is a normal condition of the worker's employment, and the person conducting the business or undertaking taking has taken the necessary steps to minimize the risk to safety and health so far as is reasonably practicable. Bullet item 2. The safety and health representative or the person conducting the business undertaking. You with me? Okay. Or the worker is required to write to the director requesting that an OSH officer be appointed to attend the workplace to conduct an investigation. This investigation is to determine if the work in question is exposing the worker or other workers to a serious risk to safety and health emanating from an immediate or imminent exposure to a hazard. Upon receiving the request, the director is to acknowledge receipt of same immediately and appoint an OSH officer to commence an investigation within 96 hours of receipt of the request. However, if the request relates to a worker in essential service, the appointment of the OSH officer and the investigation should commence immediately and in any event no later than 48 hours of receipt of the request.
Entire 89.
So you were proposing to delete subsection 2 of 83.2, where you would now include essential workers but stipulate these conditions. That's the proposal.
Right, that's why I was saying we couldn't delete until I went through the procedure here.
Okay.
Because this is tied into us allowing essential service workers in. There has to be some mechanism. So that's why I didn't agree yet to a delete until we have gone through this.
This is why when you read ahead, you know, it can ease your mind.
You will proceed.
All right. If upon conducting an investigation, the OSH officer decides that there is no serious risk to the worker's safety and health emanating from an immediate or imminent exposure to a hazard, the officer is required to notify the person conducting the business or undertaking, the worker and safety and health representative, if any, of his or her decision in the prescribed form, which should include advising the worker that he or she is no longer entitled to continue to cease or refuse to work. A worker who still refuses to work after the decision of the OSH officer is not entitled to payment of wages and benefits after the date of such decision, but I would say subject to the results of any appeal. I'm just putting it forward. Can I finish it and then we...
Proceed, Mr. Jamaica.
No, don't proceed. I beg you, don't proceed. Right there, sir. Because what this is also contemplating is that, listen, that worker refused to work in an area where they should have worked. And the action that is taken against the worker is, if you continue to refuse, subject to the appellate. But I want to be sure, you know, that because refusal of work can lead to another action by an employer. Because that would be they can cite insubordination or abandonment of duty. So I would want us to take that into consideration also. Yeah.
Yes, you may proceed.
If upon conducting an investigation, the OSH officer decides that there is a serious risk to the worker's safety and health emanating from an immediate or imminent exposure to a hazard, the officer is required to notify the person conducting the business or undertaking, the worker and safety and health representative, if any, of his or her decision in the prescribed form and shall issue a prohibition notice under this act. So prohibition notice, you can turn to clause 173 of the bill. And that applies where the OSH officer reasonably believes that an activity is occurring at the workplace that involves or will involve a serious risk to the health or safety of a person emanating from an immediate or imminent exposure to a hazard, or the activity may occur, and in those circumstances, the OSH officer can issue a prohibition notice and it continues into 174, 175 as to how it will lead in relation to that. Because the criteria would have been triggered there, because what you want is the situation to be rectified as quickly as possible. Read the last point. Oh. Oh, additionally, Clause 82 is to be amended to specify that where the worker has exercised the right to cease or refuse work, the issue should be addressed as stated above. This means that the issue should be referred to the director for an investigation as opposed to the tribunal for settlement. So this is carrying you back to resolution of OSH issues in 80, because at this point now you have ceased or refused to work. So what we're trying to do is to get these issues addressed as quickly as possible, and for the situation that has caused the worker to cease or refuse to work to be rectified. So
as quickly as possible in this case is 96 hours.
For non-essential, yes.
For non-essential, in terms of the investigation and of the usher officer, and 48 hours for the essential services. And the prohibition notice, failing to abide with the prohibition notice, the director can actually, now we're going to look at those provisions. We haven't gotten there yet. There can be remedial action by the director, and then he can recover the costs. Don't know if that will stay, in that the director could actually fix the situation. And also, there can be an application for an injunction, although that will still have to be tailored in terms of the action. Yes.
Members?
Is your intention to expand the scope of essential service beyond the LRID schedule?
No, because as you know, the ILO is already concerned that we have too many essential services.
So let me ask you, is the intention to reduce?
Not to the best of my knowledge, but
So
I can't
you
speak at that
are
level.
going to defy the ILO? You continue to defy the ILO in a new piece of legislation? As a policy of the government?
In what way?
I do not believe that that's the intent, Member Brown.
What's the result?
Because the ILO actually does allow for you to actually exclude certain categories of workers from the right to refuse work. So we were not in, the only thing is maybe not as wide, they would have had to take out certain categories, but it's not against the ILO for the state to decide that certain workers that provide certain essential service could be excluded.
Like telephone services?
No, as you know, essential services varies from country to country.
I could understand the days when we have to line up at Jamaica to make overseas calls and so forth, that being an essential service. But now, whenever beggar have 2, 3 phones, I don't know, and I can't, yeah, so I don't know why we need to continue to discriminate against some workers by calling them essential service. Though in the era of states of emergency, they do enjoy being described as essential service for freedom of movement. So I don't know, it's a matter we should look at though, as to what is essential service. Because you want to bring in the army and the police under that. So you're expanding it. But there are some there who are really no longer, airline people for example. Not essential service. Shipping, not essential service in the old way it used to be. So maybe this is a time to look at those and to be guided by the ILO as we're being guided by them in this legislation. And Chairman, just one other thing I want to say.
Yes.
There was a suggestion from the Attorney General's office earlier about phase approach to the implementation. I believe as we go further in the bill, we're seeing the wisdom
Yes,
of
we're
that
seeing,
suggestion.
yes, and I know that's something that the ministry is to revert to this committee on. But as you rightly said, Member Brown, more and more the need to have the phase implementation is becoming real. There are certain amendments that we need to agree on, and I go back as far as clause 85, and I see Mrs. Bennett Campbell has now moved us to clause 89. But I believe in clause 85 we were to agree to the deletion of the word refuse. Is it? Yes, refuse as highlighted by the AG's chamber.
Chairman, there was a clause prior, I think is 83.1, which way seems to be dumping now, deleting.
Yes.
Defines cease work, and cease work meant refuse as well.
Yes.
So to say cease or refuse when cease include refuse, if we still maintain that.
Yes.
The refuse is unnecessary. Cease include refuse.
That's
the
so.
term that they're using here.
Yes. So we agreed to delete the word refuse from 85, 1 and
Keep the definition of cease to include refuse. Otherwise, they're two different actions.
yes, but that was dealt
I
with
have a little
earlier.
difficulty with that because, as I said, in relation to the right to issue directions, I don't think it's appropriate to issue directions to refuse, for me to refuse to work. If I take the decision to refuse to work, that cannot be because you should not peg that to a direction being issued. And then if you don't issue the direction, does that mean I can't refuse to work? That's an individual decision. And I'm concerned when we twin the concepts that we would now have an issue, for instance, in that situation. So I take your point, Senator Brown, and I think when we are going back over whatever amendments, we'll have to bear some of these nuances in mind to see what we can pair and what we need to leave separate and distinct.
Very well. So we agree that we delete the word refuse from 85.
In the context of
in the
what
context
AG
as so, yes.
department is.
In respect of 85.6, is it that members, and I know Member Scurfy, you had made a submission on that point, is it that the committee is asking for 85.6 to be deleted? 6, yes. Could we have a ministry have any position in that regard? The deletion of 85.6?
Minister, we'd prefer to discuss it and look at all the implications before we come and agree.
All right, very well. So we'll revert to the committee in that regard. Could you just take us through 86, 87, and 88, Minister? Members, do we have any comment in that regard? Yes,
We have
Mrs.
to remove those provisions if we are adopting what was just proposed. Won't we have to remove 86? Because the procedure, if we adopt the procedure that the ministry is proposing.
89.
No, I'm speaking of clause 86.
Okay, very well.
Because there's a notification procedure that Yeah, the entire provision will have to be reconciled.
It's going to be very difficult because we would need to go back through the
From
new
83.
proposal. There would have to be some reconciliation with what is in the bill and what is being proposed as a new procedure. So it's going to be a little difficult. Well, I don't know if the ministry is up for the challenge, but it's difficult for certainly AGs, I think for the legal departments to be able to comment now on what is in the bill as opposed to what has been proposed. We would need a little time.
Very well. Member Brown?
Yeah, and I agree with what the Soldier has said. At 86, a worker will refuse to work under Section 84. 84 speaks about a worker who may cease as against refuse. 85, we're taking out refuse. So I don't know how is 86 saying a worker who ceases to, or a worker who refuse? Two separate actions. Is it intended to cover cease as well as refuse, or just refuse alone, but not cease?
Whenever it's the worker, it's cease or refuse to carry out. There are errors on the face of the bill that it's not following the language that should be there.
I agree with you, but we here have to respond to what is here. So what I understand you to be saying is that we're going to make the adjustment at 86 to cover what was intended.
Yes, and to reconcile it with the procedure, the new procedure we had highlighted.
Chairman, I just want to make it clear that
But we need those.
I am not making a commitment yet on the new procedures because I want to see everything together.
Very well.
It's just that we have to work out the action of seizing and the action of refusal, because you can be instructed based on 85 to seize, or you can seize in the first instance and in 84 and you are demanded to continue working and you refuse.
And come on, and through your chair. At 86, a worker who refuses. At 87, a worker who ceases. Clearly, two different actions intended.
Yes. Ministry?
Yes, the language needs to be reconciled because, all right, 86 in relation to B is saying that the worker should remain available, to carry out suitable alternative work. So 87 now was speaking that about the worker who ceases work under either the direction, under either 84 or 85, that's why it cease or refuse. The person conducting business undertaking may direct the worker to carry out suitable alternative work at the same or another workplace if that work is safe and appropriate for the worker to carry out until the worker can resume normal duties. So it's speaking about the worker under 84 as well as the worker under 85.
See that, but it speaks about one ceasing, one refusing. And so the conflict between cease and refuse.
So it's really the consistency in the language.
Yeah, are they synergy? Are they coming together? Synchronizing of cease and refuse need to be addressed because it gives the impression that we're talking about two different issues, two different set of actions. So, and it comes up in 88 if a worker cease or refuse. So that set of language need to be resolved, coming right through to 88.
89, yes. Yes. Do we have a comment in that regard, Minister? Yes.
Just going back to the matrix again, because in relation to comment clause 86, AGC, it's page 40 on mine. Clause 86 is to be amended to specify that the worker, this is a reference to the worker who has ceased or refused to work under Clause 84, and the worker who has been directed to cease unsafe work under Clause 85 are to remain in a safe place at the workplace during his normal working hours until the current concern has been resolved, and shall remain available to carry out suitable alternative work and to assist the investigation.
So this is the proposed amendment
Yes.
to clause 86.
During this period, the worker should receive his, I had said normal wages and benefits, but that's not the language of this bill. So looking back, the pay that he would otherwise be entitled to receive performing his normal duties. But you told us to look back at 72.4, which is where this language is taken from, so we'll reconcile the language there.
Yes. So members, we have an amendment to clause 86 as stated on page 28 of the matrix.
Just to clarify, in that amendment, the worker is to stay at the workplace?
Yes, when we reviewed, because we're not trying to get this confused with what is a strike action. So you cannot do that particular work, but if you can do alternate work and stay at a safe place at the workplace. But the language should be nearer to 86 though, because it says same or another workplace, if that work is safe and appropriate for the worker to carry out. So we do not want this to be confused with a strike action, especially since we're including essential services.
Strike action, I know Senator Gill and myself want the workers to stay there. There's something called picketing that we like. But does this rule out in an unsafe environment the workers being sent home for the day? I mean, let's take moles begin to pop up in a records office somewhere. Would we want to keep those workers there?
It's a safe place, the proposed amendment says a safe place at the workplace. I don't know if that addresses.
Yeah, but
I don't know if
you
that
take
addresses.
a place like this with, where in every room the same air is circulating.
Yes.
All right, I'm talking in here in the parliament, so that our at Oceana are wherever as the complaints have been in the past, so that South Camp Road, you may not want them to stay in the workplace because the whole workplace may be unsafe. So it's just that I want to guard against the requirement or some other location, maybe there, which is safe, is what we may want to use rather than saying at the workplace or at a safe place in the workplace. Because nowhere in the workplace may be safe.
Okay. So you... Yes, Member Gill, before you come in, let me just hear from Ms. Benkama.
Some other jurisdictions were reviewed also said or as directed by the employer. So I don't know if that would address your concern if you put in something like that. So stay at a safe place or as directed. So if the employer had said or PCBU had said that I don't have anywhere for you to remain that is safe and you can go home.
Directed by the employer may be limited because they may direct you somewhere. So if you put in as another safe place as directed by the employer, it would cover it for me.
Member Brown, let me hear that. At another safe place?
As directed by the employer.
As directed by the PCBO. Ministry, do you have that language? Do you have any comment on that?
Marasco Road, chlorine leak at Marasco Road, for example. You will have to send them some Mona or somewhere, which is part of the same workplace. But it can't be that you say there must be, because it depends on what the issue is. A chlorine leak, you don't want nobody there.
Member Gill?
Chairman, again, you know, things come at me that might cause issues. And another one is alternative work. So, I refuse. I have ceased because of the exposure. An employer says, well, I have alternative work for you. And in some instances, we talk about jobs changing and you have comparable roles or comparable functions. So there are two dimensions to it. One, what is alternative work? Do we need to define it? Or two, what happens if alternative work is not available? As Senator Brown suggests, the worker go home? Or does the worker need to remain? Will the worker be paid? I'm just asking, in the event of these scenarios.
I want to follow up on that point because just to use the word suitable alternative work, is this work within my job description, scope, my skill set? Because the work can be suitable to be done, but that wasn't what I was employed to do. So how do you reconcile that? Well, just to have it as broad as that. And then if you tie in 87, that the business, conducting the business undertaking may direct the worker to carry out that suitable alternative work.
Well, I think
and if I refuse, no, let me just complete my, if I refuse, so I am a lab technician, for example, at the particular workplace, and there's issue in that lab. Then you send me to account to help to file some documents. No, it's a practical thing, but I said, no, that wasn't what I was employed to do. And I refuse. So you may direct, so the direction comes. I refuse to go to the accounts department. How do we reconcile that? Would I be in breach? Because my original terms of engagement, that wouldn't fall in my scope to so do. Or the management says, okay, we have some things to move from block A to block B, so we need your manual help here, just to occupy the other 2-3 hours of the workday, because my immediate workplace is not safe. So you say you may direct me to do alternative, but how do we qualify alternative? Within my same skill set, within my job, alternative can mean just another set of work, but it could also mean alternative directly resembling what I'm supposed to do. And if the worker refuses, how do you reconcile that?
Well, remember, before the ministry comes in, though, I think suitable in that context, if it is work you cannot do, then you're not suitable.
No, I can do it, so I can carry some, I can dispose of the garbage.
Yes.
For example, what I was employed to do, that I was employed as a lab technician. So it is suitable to be done, but is it within my scope of work, my job description? Was I employed to do that? So we have to understand what do we mean by suitable. Mm-hmm. So that's the point I'm making. So yes, I can do it. Mm-hmm. There's gas fumes in the chemistry lab, so we have to close down work for the day.
Yes.
So you don't want me to play domino under the tree. So you say, scare-free. Go and mark the field. Go and get some.
Sell in the canteen. Yeah.
Right. Go and help man the canteen line. Is that what you mean? I just want to be clear. Are suitable within my same skill set? I just want the clarification.
Yes, Mrs. Benny Campbell.
And for this concept, if you look at the Employment Termination and Redundancy Payments Act, it speaks about an offer of suitable employment in relation to the employee. And if it is that you have unreasonably refused an offer of suitable employment, then you can be disentitled from a redundancy, entitlement to a redundancy payment. Now, it also now there's a lot of case law that had set out what is suitable and, to fill out what the legislation had done there. Because the only guidance it gives is that the place in which he would be employed would not be more than 10 miles from the place at which he was employed on the contract as in force immediately before his dismissal. So he couldn't send the worker from, I don't know distance well, but I assume that's Kingston, and send him to Montego Bay. So I don't know if it is that, well, we depart from how we did it in ETRPA and we try to set guidelines, or is it that we give some minimum guidelines and really leave the court to flesh it out? Because the court has fleshed it out under the ETRPA in such a way that you would not have been able to capture all of that in legislation.
No, but that is one.
It could
So
not be a reduction
I want to be
in
clear
pay.
as to what our intent is.
Yeah, it could not be a reduction in pay, for example, because it must be that you're getting the same pay that you would be entitled to is what we had in mind. It could not be, like the ETRP said, too far from what, in terms of location. It could be, must be something that was in the skill set for you to actually do. That is, those are the kind of concepts we had in mind.
No, but I'm not even looking at, let's say, the issue occur for an undue period. So a day or two at the workplace, because you don't want to send them home if you don't have to. So I just want to be clear as to what can be the alternative in this context of suitable. So for the worker has to be clear on that, and I don't think how it is worded here, it gives the worker sufficient protection. It's more skewed towards management dictating what ought to be done to keep the workplace alive, and I don't know if the worker has sufficient latitude to say, to refuse. So the worker ceases to do a job, management may give you a suitable job, but the worker can refuse, or the worker cannot refuse based on this fall outside my scope. So I just want to be clear as to the intent of the provision, and I don't think it is, I'm not satisfied that clarity has been provided.
Chairman,
Yes,
I'll
Member
go back to the alternative work. And also, this can be an instruction by the employer to cease. Yeah? And I recall one Monday morning, just like this, a particular bank that has branches. When the workers came to work, the branch was flooded out. And so it would be unsafe for them to operate. And so the management advised that those workers who operate on that particular area, in that particular area, would have to relocate alternative work at other branches. But then one worker was sent to Portmore, and it would have placed that worker in a precarious situation based on just normal pickup and this like that with kids. And so these scenarios would come up in terms of location, because the bill assumes that notwithstanding your refusal or the instructor cease, you are still at the behest of the employer to perform. And so the notion of alternative work has to be taken into consideration, that it must not just be limited to what the employer is instructing, but take into consideration the possible inconvenience to the employee, because you assume also that whatever may have happened is not a cause of the employee, but the establishment. And so these things are going to come up in, and these are the things that Member Brown and I are going to have to deal with. And these are things also that your officer, who has been given awesome responsibilities, are going to have to navigate around. before making a decision.
Mr. Chair, just quickly on that point. We don't want it to be seen also that this quote-unquote suitable alternative work is now seen as a punishment to the worker because I seize or refuse to this job. So the employer says, okay, you stop my productivity. Okay, go and mow the lawn, for example. And then I see it as punishment. And if I have no right to refuse, then what is the end result? So it's critical that we flesh out this suitable alternative employment. Bear in mind the fundamental rights of the worker to work in a safety and healthy environment.
Yes, Member.
Normally, in a workplace, this calls for flexibility, calls for dialogue and discussion. I'm a grade 1 welder. We have a sports club, and yesterday there was a big cricket match. A lot of battles on the playing field. But there's a problem in the welding shop that I can't perform because there's an exposure of a 220 cable. And then I'm told, all right, on the same compound, we're going to ask you to go down to the playing field and find all the plastic bottles. Yeah, let's use Kirkvine, that is out of commission. So go and pick up the bottles on the ground. It may be an order from my supervisor with whom I don't get on well. It may be an order from the CEO or the PB's personal conducting business, PCBU. How do we get that flexibility? Because that's really what we're seeking.
Yes, I did.
But there are real problems unless we define what is suitable. And as you said, there are case law which says what is suitable. In the Employment Termination Redundancy Payment Act, there is. But you can't just import that here. So we can define what is suitable based on some of the judgments we have seen. So we don't get into a situation where at the workplace are free for all. So we need to define the suitable is what colleagues are saying, and I agree with them.
Mrs. Bennett Campbell answers.
Yes.
Whilst Member Brown speak about the importation from the Employment Termination Redundancy Payments Act, that took into consideration employment of a comparable alternative job. What he's speaking to is work. There's a distinct difference between a job and demanding for you to go do some work. And in this case, an employer may say, I have some work that needs to be done in a particular area that I never engaged anybody to do it, but I need it to be done, so you can go do it.
Mrs. Bennett Campbell?
Well, we'll look at it, but as I say, the problem is that when I get down the definition, if I cannot capture every circumstance, then the PCBU can then abuse the provision. So while we can, when we're giving the guidance, we have to be careful how we do it, because then that's going to be used as the interpretation once you put that definition. And when you look at the language that developed under the ETRPA, and based on a case-by-case basis examination of what is reasonable in that particular case, it will be difficult in my view to cover every situation, while we can give some general guidance.
Chairman, I said earlier the road to hell is paved with good intention. What, as a union man, I don't want is the creation of new disputes in the workplace, because we have this good thing, but it creates disputes. Nothing turns off a worker like telling him to do something below, in his perception, below his or her dignity. And the labor code says dignity must be accorded to the worker. And the way we have tried to resolve it is to plea flexibility, plea consensus. But when you begin to put things there which says to an employer, you can just give other work, it is going to run up against the welder, the electrician, the typist, and the others who think, and the lawyers, who think that because the building is unsafe, I want you to count how many cars drive past the building. And I know none of the lawyers are going to go out there and do that. So that those are the things we need to avoid, creating more conflict. I understand the good intention, but what I don't want, because I think I understand the workplace, there are good people and there are bad people in the workplace, and it could create tension, could create problems, and let not safety be a source of division. Let safety be a source of healing and unity and flexibility. So if we find a form which says after consultation or something, but it gives the worker a say and it doesn't leave the PCBU with the sole thing.
Practical example.
And again, as I say, the role of trade unions. We play more than just striking and fighting for more money. We try to build harmony in the workplace. And there's no role for it. In a workplace with a trade union, an active trade union culture, there's no role for the trade union in this. It's becoming the worker and the person. And believe me, we have built a lot, we have made a lot of progress because we have been flexible and we have looked at the best for all the parties there. But this bill, again I say it, excludes the trade unions.
Not true.
Just a quick practical.
Yes.
I tend to look at practical example, and this is why I take this so important. Some of the lower quote-unquote level workers. So you have the groundsman, the lawnmower not working today, so he can't do his job. You say, okay, go wash all those cars in the park. And the weed whacker, unsafe. Right, it's okay, so you can't cut the lawn today, for example. So go and wash those cars. Is that suitable alternative work for the groundsman? I wash my car and senior management car. So those some of those little issues we have to look and see the application. Sometimes the words nice and fancy, but when you cut beneath it and the application, for some of those workers who might not have the ability to be unionized or to get lawyers, the law must protect them also.
Any comment from the legal teams? Legal reform? Or Minister?
Minister, if you'll allow me. Yes.
Proceed, Mrs.
Yes, I take the points that are being raised. I think they are reasonable points, and I think it's something we can look back at. Member Skeffrey asks, what is the intention? The intention is that it would be work commensurate with what the worker does. That is the intention. However, we have to ensure that the legislation reflects that intention, so we can take a look back at that.
Yes, very well. Mrs. Bennett Campbell? Yeah. Mm-hmm. All right, so in respect of the amendment proposed to Clause 86, the committees are asking that the ministry look back at the use of the words suitable alternate, suitable alternative work in the proposed amendment that is here. That's it? So the ministry again will come back to you on that. We move to 80. Yes, so could we go to 88, Mrs. Benny Campbell? So 87 and 86 and 87, ministry will come back. Move to 88. All three. All right. 86, 87 and 88. So could we go to 89, members? You have heard the amendments, which is one to delete what you have there and replace it with what has been put forward by the ministry. I don't want us to.
Well, we just have to see what the final outcome would be in terms of the amendment to 89 as being proposed by the ministry.
Ministry, okay, fine. So we agree to the amendment as proposed.
We agree to the principle of the amendment. But
Yes.
we have to wait until see what the outcome is.
Oh, when you say outcome, you mean the draft?
The drafting.
Oh, very well. Okay. So you are, yes. So you have, we have agreed to deleting in the first instance, and secondly, to the redrafting of clause 89. Do we agree to that, members? Yes. Very well.
Chairman, just to be clear, the proposals that have been brought to our attention from the ministry, the AGC still has some reservations on a few aspects.
Yeah.
So when we do see what the redraft looks like, then we will comment.
Very well. Very well. Mrs. Ben-Campbell, yes?
We had kind of jumped over 88 because I had to explain 89.
Yes.
But there was something to be addressed in 88.
Yes. Proceed. So we're going back to 89. 88.
I'm going to LRD. I'm not going to deal with or refuses to carry out work because we know already we have to look at consistency in language there. Point 2, what does the term continuity of engagement mean? Is the term legal reform? You're okay with me reading what you said? Okay, sorry. What does the term continuity of engagement mean? Is the term continuity of employment preferably in Jamaica? We were saying the words employment or should be inserted immediately before the word engagement to encapsulate employees and independent contractors. However, and point 3, what was the term prescribed purpose mean? So we had said delete the words for a prescribed purpose. But let me read 88 because we have to go further than this deletion. If a worker ceases or refuses to carry out work under sections, we know already it's not necessarily 84 to 89, we'll fix that. The action does not affect the continuity of engagement of the worker for prescribed purposes if the worker has not unreasonably failed to comply with the direction to carry out suitable alternative work at the same or another workplace and that was safe and appropriate for the worker to carry out. So in terms of what would be prescribed purposes, so, you know, for certain labor laws, certain statutory entitlements, continuity of employment is very important. So, statutory entitlements would be one, such as redundancy payment, leave entitlements such as maternity leave. It may also impact superannuation benefits in terms of continuity, allowances such as seniority allowances, for example. So what the provision is trying to say is that your continuity of employment should not generally be affected because you have failed to carry out the work. And we will fix the whole thing about reasonable and those issues we discussed. So prescribed purposes, that is what it was intended to capture. So I don't know though if what we should probably do is instead of putting it in regulations, seeing that it's a few circumstances, we could probably put it in the body of the section.
Why not just say that that the cessation under clause 84 or whatever does not affect the employment relation? So it covers everything, whether seniority, whether redundancy, maternity leave, all of that. If you say just does not affect the employment.
Mrs. Celia Brown, you have further discussions? You have any comment? No comment. Legal reform? You raise the point.
Mr. Chair, I don't have a difficulty with the explanation given by the ministry. It's just how it is worked into the legislation.
Yes, Ministry, I've heard Member Brown's comment. Any reply? And is it that you're proposing that after the words engagement, you include or employment and you delete the words prescribed purposes thereafter?
Well, I believe continuity normally has to do with employment as opposed to independent contractors. When I look at the legislation in question, I don't know if there's a context in which the continuity would apply to an independent contractor.
But the definition of a worker here includes that independent contractor. And so what we're saying here, it doesn't matter whether he's independent or not. It's a worker under this definition.
Okay.
But the continuity we're speaking about is not under, it's under other labor legislation, it's under superannuation benefits, it's under certain allowances such as seniority.
Very well.
Then that the independent contractors, that's not part of their entitlement. Right. So that's why we are saying use the terms and conditions of employment. Because once you start specifying and differentiating the worker, to which we have included all of these are workers, it becomes an employer will nitpick. Once you start differentiating.
Member Gill, so you're saying that you should just have that it does not affect the terms and conditions of employment or engagement.
Chairman, just
Sorry, what's the rationale for engagement rather than employment?
You use engagement normally for independent contractors and employment for workers, and that's how it has been used in the bill generally. So normally when you're saying employment, you're normally using it in that context, and engagement for the independent contractors. Well, as long as if you say terms and conditions, it makes it clear that it also includes continuity, because we really, when you look under the ETRP and so, you would not see this circumstance under what doesn't affect your continuity. So we don't want we definitely don't want the continuity point to be lost.
The regulations to the ETRPA speak specifically to break in service and a number of other issues like that. That's set out in the regulations there. But we are going further in this. We're saying that in any legislation, it must not affect the continuity. And maybe we want to, in any enactment, so that it covers all of those legislation that may be impacted, so that this supersedes them in that respect. That's what I believe you're trying to get at. And we can craft the language that achieves that.
I wouldn't have any objection to that, because as you know, this would not be listed under the ETRPA as one, in terms of what breaks continuity and what doesn't. So it wouldn't have been captured.
In other words, if I don't work today, that should not affect my holiday with pay because of the safety issue. That's what he's saying. So we capture all of these legislation, any other enactment, whatever the term usually is. So it brings the workers into the protection. Where are with you on that? I think it's just a drafting issue.
So, Ministry, you have heard the
Yes.
recommendation?
Well, we agree with the recommendation, so we just want to make it clear that although we're deleting the words for prescribed purposes, it's so that we can insert something in the body of the law, which
Yes.
isn't captured in our comments here, so that's what we want to be clear for the records, is that we
Yes.
would prefer to capture what we intend on the face of the law instead of you having to look for a regulation to see prescribed purposes.
Okay, very well. So let me hear what is being put forward for the agreement of the committee. Mhm.
I have to look at it in terms of what is here and what is proposed.
Mhm. All right, so
Chairman, I don't
you'll,
think they have the draft
we-
of what.
very well. So you'll come back to us in respect of clause 88, Ministry.
Yes, I would prefer to consult with the drafter in
Very
terms
well.
of what I would be doing there.
Very well. So that would now take us to clause 90. It's now 12:59 members. Yes, I do bear in mind that a certain member indicated that he has another engagement at 1. Yes, we are scheduled to come back here on Thursday, but we're, we're scheduled to come back here on Thursday. I have learned this morning that the Senate will be meeting on Thursday, and if you look at the composition of this committee, the quorum is at risk. So I think it is in our best interest that we suspend the sitting that was scheduled for. No, I understand. You're the suitable alternative. Yes, so what it means is that I am proposing that for Monday of next week, which is the next scheduled date, we do an extended sit-in, which means that it will take us up to 4 p.m. We certainly will break for lunch. Yes. Yes, Member Gill.
You'd advise Parliament so that they can make lunch available.
Certainly, we will do. The clerk will ensure that the relevant notices are issued. Yes. There any other business?
If you was not good chairman, I would say I want to make sure there's rum cream for on the agenda too, but you're a good chairman, I withdraw that.
I don't. Yes.
Monday only, right?
Yes. Yes. Yes, I think so. The McNaughton rule is kicking in. Yes, so I think it is a convenient time. So may we have an adjournment motion for adjournment?
So much, yeah.
All right, thank you, members. This meeting stands adjourned.
So I should take this off the calendar?
No, not yet. Monday we deal with that.
Okay.
stay calm. Stepping on the place like a lightning storm. They up on the ready man a ring the alarm. So them coulda never try take the king for your